2015-291, State of Arkansas versus Gordon Cox.
Your Honor, Mr. Cox has retained us to represent him privately. This is his first appearance, I believe, on these charges.
It is.
Your Honor, we enter a plea of not guilty to all the charges.
The case, court notes the plea of not guilty. The charges being use or possession with intent to use drug paraphernalia, D felony, and possession controlled substance methamphetamine, a separate D felony. The court will note the plea of not guilty. Also note the fact that this case is on the Division 3 docket and will set it for reappearance on October 1st of 2015. It appears to the court that this matter that arrest was made in this matter on September 17th.
Your Honor, would you ask Mr. Cox or Mr. Cox to appear to his probation officer this afternoon, please?
All right. I'm going to direct you to meet with your probation officer this afternoon.
Yes, sir.
Here in town. All right. You may be excused. 2015-140, State of Arkansas versus David Jones or David Woods. Mr. Woods, then you're appearing at this time to enter a change of plea on the charges against you, is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that
Yes,
correct?
sir.
And have you had a chance to discuss the terms of the agreement and the punishment you're to receive?
Yes, sir.
And are you satisfied with the advice and the representation Mr. Cooper's provided?
Yes, sir.
On the plea and the charges that are being amended by the agreement in this case to obstruction of governmental operations, a Class A misdemeanor, how do you now plead?
Guilty, sir.
You're entering this plea of guilty pursuant to the agreement. The agreement is set out in writing in this document I'm holding up called a plea statement. And this plea statement sets out all the terms and conditions of this agreement in writing. Have you gone over it, read over it?
Yes, sir.
And is that your signature that you've signed it?
Yes, sir.
Okay. And do you feel you understand what's set out in the plea agreement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties?
Yes, sir.
You understand the rights that you give up by pleading guilty?
Yes, sir.
The most important of those rights you're giving up are the right to a jury trial, the right to be represented by an attorney and have the assistance of that attorney throughout the trial. You're also giving up the right to confront the witnesses that would appear and testify against you at trial, and you're also giving up the right to appeal. Do you understand those rights? And understanding the rights that you're giving up, are you now are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty here today, do you acknowledge the truth of the allegations against you?
Yes, sir.
Do you acknowledge that during the time period around the April 16th of 2015, you were located here in the area, and that I assume it has something to do with the name change, that you made it difficult for the court, for the police department to monitor you in terms of your registration requirements?
Yes, sir.
And you're acknowledging that you were going under a different name other than your true name?
Yes, sir.
All right. On that basis, the court will accept your plea, find that you have freely and voluntarily entered your plea. You've done so after consulting with an attorney. You acknowledged here on the record your correct name, and that the facts sufficient to establish the crime involved, and on that basis, the court formally accepts your plea and finds you guilty of obstruction of governmental operations, a Class A misdemeanor. And at this time, pursuant to the agreement in this case, the court will impose a sentence of 1 year in the Baxter County Detention Center, suspending 11 months, and with all but 30 days are to be suspended. You'll have 30 days to serve. You'll be given credit for 8 days that you've already served. The court will impose court costs in the amount of $200, a fine of $500, a public defender user assessment of $50, and a public defender fee of $150, as well as a booking administration fee of $20. All of those expenses will be made part of the terms and conditions of your suspended sentence, due and payable at a minimum rate of $100 per month to begin within 60 days of your release from incarceration. That'll be the order of the court. That'll be the order of the court. At this time, the court's going to direct that the defendant will meet with the probation officer to go over the written terms and conditions of his suspended sentence. I note that he's already signed that, indicating he has read, understands, and will comply with those terms and conditions of the suspended sentence. The court has signed it, making it an order of the court that he will comply with them. I'll direct you at this time to meet with your probation officer to go over those terms and conditions.
Thank you, sir.